Hello everyone and welcome. My name is Greg Murray. I'm a Wealth Management Advisor with the Newfoundland and Labrador Credit Union. In this segment we're going to be discussing estate planning, the benefits of it, what you might need to get started with an estate plan, and the benefits of course to you and to your family with ensuring that your life's work gets distributed as you wish. So when you complete an estate plan, it's like any other plan. The further you do it in advance, generally the more options you have. You won't have to feel backed into a corner with making last-minute decisions, we hope. The assets and everything that you've worked for during your life can get distributed according to your wishes to your family to avoid delays and family strife. So if this is something that would be of value to you, what we would start to discuss with you with an estate plan is to consider the points that you see on the screen, your family income needs, your property and asset registration, any insurance gaps, tax planning, a power of attorney, and healthcare directives. An estate plan can be fairly complex. It could be fairly simple, depending on how you would like things to unfold during a traumatic time, whether it be obviously your passing or a disability or an incapacitation. So these are some things that we would discuss. Again, some may be applicable to all people. For others, just some of these things will be of importance. So why would you want to make an estate plan or create an estate plan? The first thing is to minimize taxation and avoid probate fees. We live in a great country where taxation goes to pay for a lot of great programs, but with careful planning, you can ensure that you only pay what you're required to pay, keeping more in your pocket and more to go to your family as an inheritance. Avoid family strife is a significant one we like to discuss. We've seen many instances where things are supposedly understood throughout a family, that somebody's to own a special heirloom or something of that nature, and oftentimes the parent, the grandparent, has barely passed, and immediately there's tension and grief and disagreements over small things that were perhaps unforeseeable many times. Maybe if there was some proper planning in place, it could have been avoided. However, these things then often go on and cause confusion and disappointment among family members, and often tension that can't be undone. You would want to avoid a delay in settling your estate as an important component of an estate plan. You may have dependents who depend on your income and your assets for their well-being, and the last thing you would want are these assets to be held up by an administrator or a lengthy process before it gets to your family to continue their financial well-being after a devastating loss, really. To avoid loss of control of family assets and to avoid costly legal challenges are other good reasons to make a good estate plan. Some things we would discuss as part of an estate plan would be the use of a trust, possibly. And a trust is really a legal arrangement whereby you leave money or other assets or property to the trust for the benefit of a beneficiary or beneficiaries, and you have direction under the guidance of a trustee to have this property or this assets or this money go to the benefit of the beneficiary over a certain period of time, or however it may be directed in the trust. We'd look at guardianship appointments for young children. You may use a trust here. Certainly you wouldn't want to leave large sums of money to young people or people incapable of handling a large sum of money, which is meant for their well-being, their monthly income, till they finish university, become independent, etc. So a trust could be used in this instance where property is left in the trust and you have guardians appointed, trustees, to make sure that your life's work goes to benefit your family and your heirs, which is the ultimate goal. With an estate plan, you also could consider pre-planning your funeral to take those tough decisions off family members at a very difficult time. We would consider the payment of debt, and the base of any estate plan is the preparation of a properly drafted will. I think most people would understand what a will is. It's obviously a document that comes into effect on your death, and it's designed to be a statement of your wishes. We always recommend it be prepared by a legal professional, and you should review it from time to time to make sure that it's current with your stage of life and with your wishes as you wish to have them completed. A will is one of those things that everybody understands they should have one, yet it's easy to procrastinate on. It's not, I'm sure it's not great fun to plan your demise. However, you spend your life working, you get to retirement, accumulating assets, accumulating money, property, whatever the case might be, and only to have it come crumbling down possibly if you don't have a properly drafted will. So it's very prudent to have a will in place, and we always suggest having it prepared by a legal professional. And we will discuss the implications perhaps of not having a proper will or trying to do it on your own. I won't say that in cases have existed where you've drafted your own will and it's went okay. However, we will discuss some implications and possible outcomes if things don't go as planned. Obviously, a will is implemented only on your death, and you can change it or revoke it at any time if you're mentally competent to do so. So if you have a properly drafted will, we've got a side-by-side chart here that shows a properly drafted will can allow you to designate your own beneficiaries, appoint your own executor. It ensures a timely distribution of your assets in most cases. And one of the most important things we like to say is, especially if you have minor children, dependents, somebody who depends on you for support or for income, or their quality of life depends on you, then you should always have a will in place to ensure that if you're not around, that there's somebody appointed to ensure that minor children and other dependents are cared for in a proper fashion. If you have no will, some things that can happen is that provincial law will determine your beneficiaries. The court could appoint an administrator, and the courts may delay distribution of assets, and the courts may appoint a guardian. So all these things, the decisions have been taken out of your hands. I'm sure in due time, with no will, things would trickle down to your children or to your family through bloodlines, etc. However, it will definitely result in delays and very likely extra cost unnecessarily. So this is the will I mentioned earlier that you may do it yourself or in your handwriting, perhaps the one that we wrote on a napkin the night before we were going on a vacation while we're packing our suitcase or something. A holograph will is in your handwriting with your signature and talks about how you would dispose your property on death or what you'd want to have happen. It doesn't require a witness, but again, considering it's going to control your life's assets, your life's work, we certainly don't recommend it, as any slight error, improper wording, misinterpretation could throw out the will or make it invalid, or even result in an improper disposition other than what you had intended. So, the formal will is what we recommend to be completed by a lawyer. You want to keep your will in a fireproof place, safety deposit box perhaps. An important point here is to know that your family knows the location of your will. We've often seen executors looking for wills because in the next slide we'll talk about the responsibility of an executor, which is locating the will and ensuring it's the most recent. So it's important that when you do your will, at least let your family or executor know where all your important papers are located. We often hear reference to the term probate, sometimes in a negative connotation, but it has benefits. It proves obviously that the will before the court is the most valid. And here's where I referenced the executor's responsibility right out of the gate, is that a search was made for the most recent will, and the one before the court is the most recent and valid. And even if the executor happens to inadvertently swear falsely, you could be liable, the executor could be held liable. So an executor is quite a daunting task, and we always recommend you choose your executor very carefully. A power of attorney is another document that we frequently recommend having completed in conjunction with your will. We say it could be one of the most important documents that you'd ever sign. A power of attorney is a document that you would use to give someone else the authority to sign on your behalf in a variety of situations. The general power of attorney often doesn't extend into decisions regarding your medical treatment or condition. The power of attorney we talk about here would be, a practical example is if you have somebody who works away. We have a husband and wife, for example, and turnarounds are very popular here in Newfoundland now, 3 weeks on, 3 weeks off, whatever the case may be. So if one spouse is frequently away, working or absent in some capacity, and the other spouse is trying to conduct business and get things done, perhaps a power of attorney would help the spouse who's left behind conducting the business to get things done easier, faster, while the other spouse is away working or absent for a period. So these apply in situations such as financial affairs, signing financial documents or things of that nature. So obviously a power of attorney is a very powerful document, so you'd want to select this person wisely, and we commonly find it between spouses or maybe between a parent and a child as the parent becomes elderly and is unable to conduct their own business, just not wanting to go out, etc. The power of attorney for financial affairs is valid only as long as you're mentally competent, unless there's some wording to make it enduring. It terminates on your death or if the person you appoint passes away, and it can be revoked at any time. A living will, or a healthcare directive here in our province, is a power of attorney for personal care. It names a person to make your personal care decisions if you're incapable of doing so. It can include the giving or withholding of consent to medical treatment. And we're seeing some decisions here lately from the Supreme Court of Canada that this is becoming a more and more important issue. People want the right, if they're mentally competent to do so, to make these choices to withholding treatment or whatever the case may be. A huge benefit for having a document like this in conjunction with your will and the regular power of attorney is that in the event of your incapacitation, it takes away a very difficult decision from the family members that are left. You might have during your lifetime made it very clear to your family what your wishes were, but in that particular moment when the family is approached by a doctor, grief-stricken, it's a very emotional time. If you had a living will in place, it would give the family some comfort that at a time when you had a clear conscience, clear mind, you actually had the whereabouts to go and prepare this document so that it would take difficult decisions away from your family members at a very emotional time. So it helps give some guidance, again, during a difficult time. So I mentioned earlier the power of attorney for financial affairs, and the enduring one would continue to be valid even in the event of your incapacitation. So if you need somebody to conduct your business, if you were to have a stroke or were to be in an incapacitated state, then you would make sure that your power of attorney would have an enduring clause. I spoke earlier of trust as a use in estate planning. A trust, again, is a legal arrangement that you could establish during your lifetime or to come into effect after you pass. Some of the common uses for a trust are holding assets for minor children, for managing assets for beneficiaries who lack the ability to do so. It could maintain privacy with your assets as they pass from generation to generation. The most common use we would find for a trust would be ensuring that children from a previous marriage are provided for. Today, second relationships are very common, And as we prepare financial plans for people, it's often a common goal that if an individual is in a second relationship, they arrange their affairs in a fashion that if one passes, their assets go to the use and benefit of their current spouse. Then when that current spouse passes away, they would like the assets to go back to the benefit of their children from the previous relationship. So this is a common use that we see in financial planning, where a trust would be of great benefit and could achieve that financial objective that you wish to do. There are many acronyms in our industry: RRSPs, TFSAs, RIFs. Here's another acronym that is it's a great program that we like to make people aware of. It's called the Registered Disability Savings Plan. It's a program that is sponsored by the federal government. It involves bonds and grants that come from the federal government that encourage parents or others to save for the well-being of an individual with a disability. The turn-on point for the Registered Disability Savings Plan is qualifying for the disability tax credit. So if you have a child who qualifies for the disability tax credit, if you yourself qualify for the disability tax credit, you can open a registered disability savings plan to begin saving for security of their financial future. The biggest benefit with this is obviously to encourage the savings for someone's future well-being. The added incentive is that relatively small deposits are the turn-on point for government bonds and grants from Service Canada. The level of bond or grant that you receive is often dependent on your income or your family income. However, if you qualify for the disability tax credit or you have a family member who qualifies for the disability tax credit, you'd be doing great favor. It's a great savings program if you were to make your family aware or to inquire yourself on a registered disability savings plan, as there's great incentives to save, again, for your financial future. I mentioned earlier, anyone who's eligible for the disability tax credit can open an RDSP, and of course a representative or parent of somebody who qualifies for the disability tax credit. So where would you go next? We suggest you come in, meet with us. Let us know what your goals are, what your concerns are. Let us know what you've done to this point. Let us know where you'd like to go over the next 3 years, 5 years, 10 years. Tell us what your concerns are. We will meet with you, listen to your concerns, arrange plans and goals for you that will be attainable, we hope, plans that you can own, plans that are built around your goals, your objectives, and your concerns. And the very first step is just to meet with an advisor, come in and see us, and we can take the rest from there. And before you know, you could be on to financial success and comfort and protection that you had perhaps didn't think possible.